Hey everyone, and just a short video to run through a few motions that's been ruled on. We kind of got the gist of it yesterday with the questions Bev asked, and let's just say I felt Breenan had a really bad day in court yesterday, and these orders kind of implies that Bev is not going to roll out the red carpet for him anymore. The first one is the forensic download of the police file. That's been allowed now. So they can go and get what pertains to this case with a defense expert who downloads the program, not just, we're going to copy and paste it for you, and you're not going to know where it came from, what, if anything, we changed. They will now be allowed to send an expert to the police department and do their own extraction. Then there is, it's denied if you want the entire Canton police detective file. They don't want John Doe's DUI from 4 years ago. That's ridiculous. It was one of those where Breenan constantly over-exaggerate what it is they ask for. But I think this case will again and again and again run into that problem. Breenan keeps misstating what he's being asked. The next one is Commonwealth's renewed motion to exclude testimony from Garrett Wing. Garrett Wing is the dog expert. He is way more qualified than Dr. Crosby. That's also in the next motion. But she says, I find that he's qualified by experience to provide some help to the jury on some issues in dispute. But she will give the Commonwealth a short voir dire before his testimony if they still feel he doesn't have the necessary qualifications. And again, this guy is the guy who has his own company training courses for canines. It's called DIY Canine. You can see him on YouTube where he has been talking about the injuries. This guy is way more qualified than the next guy. Dr. Crosby is clearly qualified as an expert, but he is precluded from testifying that his bite mark analysis exclude Chloe as the cause of the marks on the victim's arm. He is not precluded from testifying as to the anatomy of a canine mouth or of Chloe in particular, including the measurements of her mouth. To the extent there is a question as to the testimony the Commonwealth may elicit from Dr. Crosby to rebut any defense expert, it can be raised at trial. Funny enough, this guy is clearly qualified. The defense experts were, he has some experience. He's not allowed to say this is unequivocally not Chloe. They will try and swing around it and say, well, if you see the difference between this mark, and Chloe has this space between her teeth, they will try and do it. But this is a win for the defense, because imagine them bringing in a mouth mold of Chloe and say, well, you can see it doesn't line up. It's a good visual. The problem is they don't have John O'Keefe's arm. They can't manipulate John O'Keefe's arm. So you can't tell if those bite marks are from Chloe. And you can't take a teeth mold 3 years after and claim it's exactly the same as the night of. So no one will come and testify it wasn't Chloe. But, and this is to all the antis, do you see what the state is doing right now? They are going along with the testimony. It's not the tail light. Why are they bringing in a dog bite expert to refute that it could be claw and bite marks from Chloe? Remember, we just saw the closing arguments today. It was the dimples inside the tail light that made those abrasions, according to Lally at the last trial. Now, even the state entertains the idea that it could potentially be scratch and bite marks from a dog. I'm not sure that's a good look. Hopefully, they will not say that. They'll say, there's no way in the world this could have been a bite mark. Then Garrett Wing is going to come in, Dr. Ross has come in and say, clearly it is. Are they then going to call Dr. Crosby to lie on the stand? Because he can't by any certainty say this is only from a tail light. Or will they not address it? I see this as a win as well. Then we have the next one, potential exhibits, no objection by defendant. Notice of display visual aids during opening statements, no objections. Introduce extrajudicial statements of the defendant. The defendant does not object to the introduction of defendant's extrajudicial statements. To the extent that defendant objects to the Commonwealth's use of an independent reader for the text messages between the defendant and John O'Keefe, the defendant should submit her objections in writing by close of business on April 18th. Remember, Breenan wants to make this community college theater where he wants someone to portray Karen Read so you can read emotions into the text messages. They should stand by themselves. They should just be projected to a screen because no one heard, no one was there. This is text messages. You read them. You can even tell the jury, just read the messages. But he wants to make it into community theater and have, I don't know, maybe he can hire Plevin and Krusty to play John and Karen. And they will, of course, be instructed to read it like, oh, John, you MF. But Karen, I just want to blah, blah, blah. The defense should object to this, and they will. Defendant's motion for specific discovery, and this is the thing where I think, dang, Breenan didn't get what he wanted. They had different things that they were looking for discovery on, and they had agreed to all the remaining disputed materials except for material 3 and 4. 3, any information including any oral or written statements or communications of any witnesses suggesting a reluctance of refusal to testify in connection with this case. So is anyone from the first case gonna say, well, we don't want to do it? We don't want to testify? Or have they other witnesses they reached out to? And why is the defense asking these questions? If you watched the Young Jerks yesterday, Betterow can't comment on it, said no comments. But why would the defense ask for witnesses who didn't want to testify? They must know someone is out there. Someone who the state have talked to who said, I don't want to do it, I'm afraid to do it, or that's not my story. I don't know. We'll have to see. And number 4 seeks any information, including any oral and written statements or communication of any witnesses wherein a witness suggests a reluctance or refusal to cooperate. Though it's a close call, arguably, this request is covered by Rule 14 and should be provided. Therefore, as to number 3 and 4, the motion is allowed. The Commonwealth must provide this information within 1 week. If the witness is scheduled to testify prior to then, the Commonwealth must provide the information at least 1 day prior to the witness being called to testify. To me, and again, I'm a layperson, I'm speculating, someone must have, since trial number 1, said something that must have reached the defense. Someone who testified from the state must have said, I don't want to do it again. It could be McLaughlin. She got PTSD from testifying, saying, I don't want to go back there. She's quite important for the state. She's the one who claims that she heard it and told police, I hit him, I hit him, I hit him. Even though, don't look at the evidence. Could it be someone else? Could someone else have had, I don't want to say a guilty conscience because that would imply they lied and everyone swore they wouldn't lie. But it's quite interesting that the defense knows someone who is to testify might have expressed a desire not to do it. We don't know what it is. We'll find out during trial, but interesting. And I see all of these rulings kind of like a loss for Breenan, because if he has reluctant witnesses that they can hammer on cross, not good for him. Garrett Wing is going to come in maybe with a short idea. I can't see how she can keep him out, even if she tries. And Dr. Crosby can't make his fantasy statement that Chloe didn't bite him. But is it good that the state now entertains it possibly could be a dog? Not in my opinion. Remember, it's the tail light who bit him.